Welcome back to Inside Sources. Today, we want to have a short discussion to open the edition on what is happening in the international arbitration case between the federal government of Nigeria and Sunrise Power and Transmission Company that is also owned by a Nigeria chief, Leno Adesanya. We recollect that last week, all day through last week, as a matter of fact, in Paris, there was an international arbitration under the auspices of the International Chamber of Commerce because Mr. Leno Adesanya had taken the matter for international arbitration because of the cancellation of what he said was an award from the federal government regarding the Mambilla power project. As most Nigerians will recall, the Mambilla power project is meant to give us over 3,000 megawatts of power. But we have been on this project, if I'm very right, for over 4 decades or 5 decades thereabout, just going back and forth. To discuss that with me today, I have a very brilliant Nigerian lawyer who has also featured here before, so that we can look at the legal issues, in a broad way, just to keep Nigerians informed about what it is that is happening. So I'd like to welcome back to Inside Sources, Mr. Ibrahim Wali.
Thank you so much, Laolo. It's always a pleasure to visit you, to come here and have the opportunity to express myself regarding these issues. And
Thank you.
It's not different this time around.
Thank you so much. It's a matter that I have taken a very definite interest in for a few reasons, especially the fact that you now have two of our former presidents actually, traveling abroad to give a testimony. And the fact that, look, this Mambilla power project has been on for over, clearly almost up to 5 decades. We've been going up and down, up and down. Not a very good report of our national life, but hopefully we're going to get around to it. So I wanted to ask you, first that. So this idea of international foreign arbitration clauses in this contract, I don't understand that because at times there are international dimensions, but it will seem, and some people have argued that it's also it's not so much a good indication of what is happening in our judiciary. Mr. Wali, can you educate us on this matter?
Hopefully. Thank you. It's quite an intelligent question. But before I go into the crux of the question, because you already mentioned 2 former presidents going in to give testimony. This matter began, I think, around 1970. Well, not the matter, but the conceptualization of the dam itself. So it went through, all those eras to President Olusegun Obasanjo. If you look at the transcripts and the reports of everything that's happening with the case,
right.
There are parts that happened during Yaradua.
Yeah.
The cancellation of there was parts that happened during Jonathan, parts that happened under Buhari, and now we're doing this. So right. 2 former presidents testifying is just part of, the whole thing, but it involves all these presidents and all these administrations. It's important to say because it has more implications, obviously, than just their testimony, because it means for 4, 5, 6 decades we've not been able to, resolve these issues regarding a very key, critical infrastructure in Nigeria. But anyway, coming back to your question, it is very important to contextualize that arbitration exists to complement litigation, right? So it is not because our judiciary particularly is slow or inefficient, but the fact that the litigation process, generally, even outside Nigeria, is quite obviously litigious by the name. It is hostile, it is contentious, and quite takes time, whether it's in Nigeria or outside Nigeria. Obviously, in Nigeria, it is exceptionally, it takes exceptional delays and stuff like that.
Right.
It is not an exoneration of the judiciary as much as it is an affirmation of the machinery of arbitration, which exists on its own and exists really to simplify the settlement of disputes. And of course, for international matters of this nature, or international matters generally, because one of the arguments, obviously, is whether, in fact, the panel has jurisdiction, but then I'm sure we'll get into more technical issues like that. But yes, it's not very much about the inefficiency of the judiciary, but then the litigation system entirely, and what arbitration offers to you. But you also have to understand that parties get to decide at the, contract stage, whether or not they want to take the arbitration route. And that's one of the arguments for Sunrise. I'm not holding any of their briefs, by the way. It's very important to say. But one of the arguments is that in the 2003 initial contract or award, there was a provision for arbitration at the ICC.
Right.
So the ICC derives its jurisdiction from parties submitting to it. And if you have submitted to it, then you will not come back and say that, obviously there are other factors, but based on the fact that whether it has jurisdiction or not, but it has nothing to do with the Nigerian judiciary. If you remember when EFCC declared Mr. Leno wanted and his lawyers went to court, Justice Epo of the Federal High Court said that the matter was already before an arbitration panel, and then they ought to respect it. They should take it down and wait for. So it shows that even the judiciary recognizes, arbitration.
Yes. Okay. One of the things that I find quite interesting, actually two things. We take it one after the other. The first one is, so it's a novelty, and I wanted to get an insight from a lawyer to have, and you are right that look, this has certainly involved 4 presidents: Obasanjo, Yar'Adua, Jonathan, Buhari, and now virtually 5.
Yes.
So, but you have 2 of them.
Yes.
Who were persuaded, who have agreed, who did present testimonies last week in Paris. And we know that, of course, it's private.
The private arbitration.
Yes. But I'm sure that we're going to get more information about it because there's going to be a judgment.
Yeah, immediately there's an award.
And when there's a judgment, it becomes public. As a matter of fact, I contacted the arbitration panel, and they said that the parties have agreed to.
One of the advantages of arbitration, and that's why parties prefer to opt to it, because you can agree for all these things.
For private hearing,
yes.
Because
some of the witnesses would prefer.
Because I thought that this is something for a reporter like me, that was a novel thing that ought to be covered. And I was trying to buy my ticket to go to Paris, but I was told by the hearing is private.
It's private.
But the novelty of having 2 former presidents. How does that look from, what's the legal optics? How often does that happen?
Okay,
to have, even in a Nigerian court, how often does that happen to have 2 former presidents, giving testimony, not to even talk of the fact that he's now abroad? What's your take on that, Ibrahim?
For starters, there's been many cases in Nigeria where people tried to subpoena or to try to get former presidents or even former public officials to come and testify, and I'm sure that most of them or all of them have gone to a nullity. So to have 2 former presidents fly to Paris, first of all, tells me that obviously they regard and respect the panel much more than whatever it is we have in-house. But in terms of the legal optics, I think what they're trying to do is to show that, because obviously I want to believe that they give testimony on behalf of Nigeria, the federal government.
Yes,
they want to show that they didn't give out the contract, they didn't affirm the contract and stuff like that. But I think what that seeks to do is to add credibility to our case that, okay, the chief the presidents at the time didn't even sanction this deal. Obviously, one of the grounds for, setting aside or for the ICC deciding against maybe Sunrise, one of the really cogent grounds, if you look at maybe Metal Talk versus Uzbekistan, is public policy. That is one of the grounds where the court would not enforce the arbitral proceedings. So public policy covers corruption, bribery, and stuff like that. So they want to make a case and say that, okay, there was no due process. They didn't. So it maybe or maybe not adds to the credibility of the Nigerian case. Nigerians, yes, but I think that the court prefers more direct evidence of bribery as opposed to absence of due process, which is not particularly, corruption or bribery, but has some elements that you can incorporate. All the same, we're not going into the technical arguments. It's before the panel. But but in terms of the national optics, I think it is very bad because, for starters, what they are claiming is £2 billion, quite some money, but I don't think it's enough for 2 former presidents to have to give testimony. And if you look at the history of the whole saga, you would see that it involves a lot of ministers, AGFs. Malami was part of it. Even Andoaka at some point was part of it. Minister Sali, former Minister of Power, was part of it. Minister of Power during Obasanjo was part of it, who is now before the court, for connected with the case.
Right.
So I think that there should have been enough officers, enough evidence, enough documents, to have to, so that the former presidents do not have to actually fly to Paris to give testimony. But it just shows the lack of due process, lack of recording, lack of. It's just, I think, it's bad faith in my mind.
Let me give you an example of why. I felt quite a bit of concern for those presidents. We've been told, by reliable authority, that the first question that was put before one of the presidents, and we'll mention his name, was that whether it is true that his daughter actually married his attorney general.
That is the problem with
that kind of embarrassment.
Yes, that is the problem with obviously availing yourself for situations like this. The other party gets to ask you all these questions, and you're subjected to it. I would have loved an opportunity to cross-examine some of them myself, but sadly, maybe if I see myself at the ICC someday. But it's just, for me personally, the fact that they don't come to us, to Nigerians, to give account and get questioned, but then they are eager to fly to Paris. I know for Obasanjo, for example, he mentioned that, I don't know, I think his minister, he's very strong against the minister, and the minister is also, so for him, he said that he wants to actually go and testify because he didn't give an approval. Exactly. His FEC didn't give an approval, but the reality is, $6 billion contract at the time. Obasanjo was a strong man, quote unquote. I don't think that would have flown under him without any. But look, I'm not the one to make any.
Exactly. That's the argument of the minister.
Yes. I'm not holding his brief because if he did something wrong, he did something wrong all the same. But two truths can.
Okay, so let's come, as we begin to wrap it up, because of our time. I just wanted to also have this important insight. So the strategy of the federal government on this matter seems, just like you've also articulated, is to nip this thing in the bud of corruption.
That was the same thing that happened in P&ID.
Yes. To say that, look, this is corrupt.
The contract ab initio.
But from all the documents that I have seen, because I've watched this very closely, you have a legal opinion, even in 2005, from the Afe Babalola chambers. I have seen, I have a copy of that legal opinion, by the way, that says specifically that there is a legal contract between the federal government and Sunrise. So when you then have the former president say, oh, look, I never approved this, I wanted to ask you as a lawyer, so how do you balance that, in just assessing the evidence theoretically? So the president is saying that, no, I was the president at the time, and it's my policy that you cannot award that kind of a contract without my say-so. But here comes a legal opinion, because in 2005 the matter had become, quite testy, and that's why they needed somebody like Afe Babala's chamber to give a legal opinion.
Yes,
and he gave a legal opinion that said that, look, Nigeria has a contract with Sunrise on this matter. How do you theoretically balance the two? How will you assess the strength of our argument as a country that this is a matter of corruption?
Okay, for starters, legal opinions are opinions, just like my chief's and just like mine, all the same, right? But I think the issue here is that, for me personally, is that even after 2003, because I keep saying that, there was no due process and stuff like that, even after 2003, there was an upstamping or some sort of affirmation of the contract by the Goodluck administration, and even subsequently by the Buhari administration, at least by some of his...
By delegated ministers to even go and talk to the guy.
And then they agreed to a settlement, $200 million in reinstatement as a local partner. So by contractual parlances, even if it was illegal, you have literally ratified and affirmed it.
By those actions.
By those actions. And I don't think that there's any law that particularly says that the president must sign an agreement or a contract, or even was given, there are certain things where the president must give approvals, but like contracts of this nature, it is not in law that, because he keeps arguing that the FEC did not give its approval, but the FEC is the president, his ministers, his vice president and stuff like that. So the constitution gives their, roles, but it doesn't say that they must actually really sign or give approval for you to give out any contract whatsoever. And at the time, the Public Procurement Act was not in force. It came in force in 2007.
Right.
And it created BPP. So, you know, I saw some arguments about BPP not being involved yet.
Yeah.
They didn't have a BPP. There are certain things, certain policies, like you mentioned, you know, but some of them weren't even codified properly.
Right.
To even say. So my concern is, I personally do not see any utility or any sense in giving out a project of that nature to Sunrise at the time. It was established, I think, 2 years before, in 2001, 2 years before the contract. Yes, they didn't have any track record. They didn't have any evidence of capacity or whatsoever. And so I'm not ratifying the contract, frankly. But the grounds, the argument I've seen from the federal government themselves, I'm not very sure. And I'm sure that is the route the legal opinion took as well. There's just no evidence, at least not that I have seen, that shows clearly that there was corruption, there was bribery, and I think that was why the EFCC and started to say, okay, let us prosecute these people. But then all of it came after they went to the arbitration panel. So it wasn't as if EFCC were going through their records and decided. But I think it just brings to fore the incompetence of our institutions, because the Ministry of Power is involved, the Ministry of Works, different ministries, different ministers, different AGs, and it's still issues on this. So we would have to wait and see.
Thank you so much, Mr. Ibrahim. Well, that's my view also, that not being a lawyer, but I wanted to check with the lawyer that, look, it seems that Nigeria, the federal government needs to come up with much more damning evidence to be able to make this another P&ID.
Yes.
But thank you so much, Mr. Wale, for coming to Inside Sources. And, we will follow the case.
Definitely.
It's evolving. We are getting more information about what happened. We will ultimately get the ruling of the panel.
We pray that it's in favor of Nigeria. I don't know how that's going to look like, but
we pray.
Yes.
We pray. But we see how it turned out. Thank you so much.
It's my pleasure, sir. It's my pleasure.